generally, probably the most important factor for the Supreme Court to get involved in an issue is that there are splits between the circuits. And this presents a pretty profound one that's there. So I think it's quite a bit better than even odds that this case would get up to the Supreme Court.
And it's weird, and I know that you take issue with that term assault weapons ban, because really they're just talking about semi-automatic rifles.
Right. Right. So one of the issues that you have here is defining what the weapons are, because the court and the Fourth Circuit said that these are commonly owned guns.
Right.
And if you follow the Heller decision, one of the things that the Supreme Court said was that it would make it very difficult for the government to ban commonly owned guns, as well as commonly owned magazines for bullets.
Right.
And so that was an important part here. But you could define it in different ways. I mean, you could go and say, well, semi-automatic guns. This gun functions, these AR-15s that were being banned in Maryland, function, as you know, as you're saying, exactly the same way as any other semi-automatic hunting rifle does. And so, if you're going to talk about it being commonly owned in terms of that sense, you'd be getting rid of not only the most popular rifle, the AR-15, but a lot of other rifles in the United States, making up a huge percentage of hunting rifles.
Right. And it doesn't, because in order for them to even have a case, they would have to basically redefine any semi-automatic rifle as some sort of unusual weapon, because I remember way back in the olden days, the days of yore, John, back in the days of the colonies, they had, different colonies had rules on and laws on affrighting, which was if you carry around a weird instrument that's considered a weapon and with the purpose to brandish and terrify people, now that they could go after. But they weren't talking about commonly used, commonly owned firearms. They were talking about like weird stuff that people would make up in their shacks.
Right. Look, a lot of the case will depend on definitions in the sense that, but I think, for example, if you look at antitrust, the question that you often have when defining what a monopoly is what's the market that you're talking about? So you could go and say, well, this gasoline station is the only gasoline station at this intersection. Does that make it a monopoly then? Or do you go and take into account that there are other gasoline stations, a couple blocks away that are going to be competing for customers? And the same thing is true here. Do they define it only as AR-15s, or do they define it more broadly as semi-automatic rifles? And in this case, though, given that AR-15s are the most commonly purchased rifle in the United States, I think they have a trouble in either case.